When it comes to website accessibility litigation, something that both clients and defense attorneys need to pay close attention to are the non-money terms of the settlement. So the focus is usually on the settlement amount, and of course, the clients and the defense attorneys are trying to get this down as much as possible. But what can become an even greater cost are the terms and stipulations agreed to. So let's start off with WCAT Conformance. If I was a defense attorney, I would seek for WCAG 2.0 conformance rather than 2.1. And that's not because I wouldn't even want to be 2.2 conformant. But when it comes to a settlement, you don't want to agree to terms any more than you have to, that go any further than you have to. Also, timeline and deadlines are very important. So some of these timelines are extremely fast, and what happens is they can be agreed to before you fully understand what is necessary to meet those timelines. So let's say you agree to make your entire website WCAG 2.1 conformance level AA conformant. Well, if you do that and you agree to have that done within 3 months, then you have oversold your capabilities, because it's going to be very difficult to make your website conformant that quickly. Also, mandatory reporting. You really don't want to be reporting into a plaintiff's law firm. So you want to curtail reporting as much as possible. You will also commonly see the requirement that you have a consultant, and that the consultant is your accessibility consultant on an ongoing basis or for however long. You really don't want to agree to this. While I recommend it, you don't want to have a consultant and be subject to paying that amount, because again, if you're concerned with money, then hiring a consultant is going to add to that. Another term I've seen more often than I'd like is having an accessibility link. So the plaintiff's law firm will require that you change your website to have a link to your accessibility statement, or something about accessibility. The first thing and it will be the first thing that a screen reader user comes across. Well, with accessibility, someone that has a disability, so maybe a screen reader user, that's not what they want. They don't want to come across an accessibility statement every time they're on their homepage. They just want your website to be accessible. So to me, this is more of something of in the virtue signaling realm, that plaintiffs' law firms really don't understand what they're doing, and they think that they're doing something, and they're requiring all of these accessibility measures to be taken into place. But practically, if you're going to a website, do you want to have to go to some terms and conditions page every time you go to that website? Or do you want to have to go through a link or know about a link every time you go to a website? No, you just want to use the website. So I would try to negotiate this term out. If you have an accessibility statement and it's linked conspicuously in your footer, anybody will be able to find it. It's not something that's difficult. So I think this just comes from a place of virtue signaling. You also have to be concerned with the work that you agree to be done. So biannual audits, for example, that's great if you can have annual audits conducted on a biannual basis, but that's a heavy cost, and maybe more than you need. Also, they might see a term like quarterly user testing, or user testing on whatever basis. User testing is very expensive. Keep that in mind. The frequency at which sometimes these terms come into play, it's too often, right? Like if we had, let's think about quarterly user testing. If we have quarterly user testing, have we even remediated, have we even taken in the suggestions from the last user testing and implemented them into our website by the time there's another user testing coming up? So this can be quite frequent depending on your website, and it's just an overly burdensome term that I wouldn't agree to. It's not that it wouldn't be great to have, but sometimes these settlements, they agree to way more than they should, and the cost ends up being much more than the money ever is. So what I recommend is you start with your own terms. So if you are familiar with accessibility and what needs to be done, you can start off with your own terms to initiate the negotiations on the terms of the settlement. And this way, it's not the plaintiff's law firm coming up with all of these burdensome terms. You want to have less specifics and less frequency. This is because it's not to your advantage. Even if you want to go above and beyond accessibility and have this rigorous program that does all of these things and has these regular audits and has user testing performed at frequent intervals, you don't want to have that be mandatory, and when you slip up, then someone can penalize you for it. You also want to have an end date to this. Make sure there is a specified date where your obligations are completed. So ideally something sooner rather than later, maybe in a year, maybe in 2 years, but beyond 2 years, you're really agreeing to more than you should. Also, research the plaintiff's law firm. Sometimes you can get the terms down to next to nothing because the plaintiff's law firm is much more concerned with the money they are receiving than the terms that you are agreeing to.